part heard appeal in the matter of RTM and Bonne, Terre and another.
My lady, my lords. So I represent the respondent RTM with Miss MacLeod, as I did below. Miss MacLeod did not act below, but in fairness to Miss Sahor, who got a mention in the transcript yesterday, who did, I should make clear that she's absent only for the very good reason that she gave birth just over a week or so ago.
Please pass on our congratulations to her.
I'm very grateful, I will. She might even be watching, who knows. By way of overview of these oral submissions, I am, if I may, going to focus most of my time on ground 2. The 3 key submissions in outline are, first, it is not legally irrelevant to take account of the subjective position of the data subject when assessing whether valid consent has been provided under the data protection legislation. And SBG and the ICO's absolutist position to the contrary is unprincipled, disproportionate and wrong. I'm not sure it really matters, but my learned friend was wrong to say yesterday that we had disavowed any role for subjectivity. We say in terms that there are subjective elements to the consent test. See, for example, paragraph 61.1 of our skeleton, page 249 of the core bundle, and paragraphs 10 to 11 of our reply to the Commissioner, pages 306 to 308. Second, the judge's approach was not simply to apply a subjective analysis, but was to evaluate the whole of the context, including a considerable range of factors which were objective. She took into account as a factor within her overall evaluation of consent the subjective position of RTM. I accept that, but I do not accept that that was the totality of her analysis, and that is not what the substance of the judgment shows. Third, there are in any event clear findings made by the judge that SBG's consent mechanisms did not satisfy the test for consent even on a purely objective basis. And so ultimately, even if this court rejected any role for a subjective element, the outcome for RTM would not be different on those findings. I'll address all 3 of those aspects in turn. Before I do so, I want to make 6 general points which address the approach and some of the big picture themes that were touched upon yesterday. And I'll then turn to deal, as the court might expect, much more briefly with grounds 3 to 5. Miss MacLeod will then pick up the baton and deal with ground 1. And we say that's an appropriate order in which to deal with the issues, not least because how this court approaches ground 2 may affect the approach to ground 1. I'm not going to spend any time orally making submissions on relief. We agree with the position set out by SBG in its skeleton at 63 that it's very difficult to do so, given the variety of permutations that might arise on the various grounds and the importance of the specific reasoning of the court on those grounds. So we agree it's a matter that will need to be addressed consequentially in the light of the approach this court takes.
Well, we did, there were some questions which related to that issue, because obviously we need to consider the submissions that are made yesterday and today.
Yes.
In relation to the judgment and what, if anything, flows from that. So whilst, of course, you may not make submissions on it, that doesn't mean the court won't ask you questions which may relate to those issues.
Of course.
Right.
I wasn't envisaging that I was going to be allowed to speak uninterrupted for the rest of the day. If I could turn then to the 6 general points. The first is, as the court has seen, consent has a specific definition in the applicable legislation here, informed by a particular legislative purpose and developed at a pan-EU level. And the consequence of that, well understood in EU law, is that it is a concept which must be given an autonomous interpretation. And if you need authority for that proposition in this context, you see that at paragraph 47 of the CJEU's judgment of Planet 49, page 637 of the bundle. Unlikely we need to turn it up. What that means we say, is that it's not appropriate and unlikely to be helpful to seek to explore the parameters and content of the concept and the definition by reference to domestic law concepts. Those are not the reference points the EU legislature is using when it drafts the Data Protection Directive and the E-Privacy Directive and the GDPR, and as my Lord Justice Lewison rightly put it yesterday, different European systems in the civil law approach issues in different ways to the common law, and all of those approaches play into the autonomous approach taken in the legislation. Indeed, it is indisputable that the approach to consent under this legislation is very different from the approach to English domestic contract law. The most obvious example is the concept, which we'll come back to today, but obviously much time was spent on yesterday in Recital 43 about a relationship power imbalance, and the example given in the guidance of an employment relationship. That's not a concept accepted or recognised in English contract law. Obviously, that is the predicate of employment law. So this one has to approach the definition and its application in a distinct and autonomous way. Second, it's important to bear in mind when one is considering the relatively limited case law on the definition of consent, both domestically and in the EU, that those cases have invariably involved the meaning of the consent standard without reference to the facts of an individual data subject. They have concerned general challenges to the legality of consenting processes, either advanced by data protection regulators, that's Leave EU and Orange Romania, both of those cases, or by other sorts of regulators or representative bodies, as was the case in Planet 49 and in Meta, or by a commercial rival, as in ePrimo. And none of those cases have posed the question or contained the relevant evidence required to consider the question how closely one should scrutinise the specific facts of an individual data subject who denies having consented. It simply didn't arise. And so in that respect, this case is a novel instance in the higher courts of the court having squarely to confront the consent standard against the specific facts and the specific evidence of a specific data subject. Thirdly, Ms. Brooks rightly dropped her Lex Specialis Gambling Act argument yesterday, but she emphasised that legislative scheme. Just one point of clarification to note, she showed you in Authorities, tab 40, page 1157, a copy of the Social Responsibility Code provision relevant to problem gamblers. That is the provision currently in force, as the bullet points below the coloured text box make clear. The version in force at the time was materially different and indeed much less prescriptive. It's quoted by the judge in paragraph 11 of her judgment, pages 68 to 69 of the core bundle. We'll come back to that later. But the Act's direct recognition that there is a class of persons recognised within the licensing objectives who are vulnerable to gambling harms and who require protection reinforces the core and basic tension inherent in SBG's position, which we emphasised in our submissions below and which the judge accepted in terms, particularly in paragraphs 98 and 186. The claimant's claim concerned marketing that was developed, targeted to and sent to him, which had the obvious purpose of encouraging him to gamble more and to do so specifically with SBG products. Yet those products being marketed are potentially harmful ones to at least some proportion of SBG's customers, and they were in fact harmful to him, as the judge found. And that's the very reason why a scheme of regulation, including in relation to problem gamblers, is required in the first place. And that is why we say, when the domestic and European courts want to give an example of a context in which direct marketing by email might be particularly harmful or privacy intrusive, they reach for the example of gambling, even though it is lawful. And you'll have seen the references to those in the judgment and in the skeleton. So simply for your note, That is the upper tribunal in Leave EU at paragraph 61. That's tab 16, page 303, paragraph 61. And the CJEU in the Dutch Lawn Tennis Association, I'm not going to try the original Dutch formulation, authorities tab 32, paragraph 56, page 853. And for completeness, that is also the approach of the Commissioner. Because at the very outset, substantive outset of the Commissioner's direct marketing guidance, authorities tab 37 at page 1007, the Commissioner identifies gambling direct marketing as a context of particular concern. And that is a significant part of the judge's assessment of the context. Nothing to do with subjectivity, and a context that everyone accepts is relevant to the assessment. Fourthly, and this is a key big picture point made yesterday, the submission of law pressed upon you by both my learned friends is an absolutist one, and very expressly so. Both say there is no role for any subjective element in the analysis of consent whatsoever. It is and has to be, they say, a legally irrelevant factor. And there are 2 points to note at the outset about this, although they overlap. The first is the consequence of it. Both sides are entitled to pray and aid the consequences of their respective interpretations. And the second is the policy justification for it. The consequence is, we say, an extreme one. SBG's case is that even if the data subject ticked the relevant boxes and so on, with a gun to their head, there would be no way for the court to take that into account, unless it was constructively known by the controller, which in most cases would be very unlikely. And it is hard, we say, to see how that is consistent with legal policy generally, or the concept of consent being freely given in particular. And of course there are other examples that are less extreme. But the point is simple. There is no room whatsoever on their approach for the consideration of exceptional cases. And my learned friends pray and aid the principle of proportionality, but a refusal to account for exceptional cases is usually the byword of disproportionality. So what's the policy justification for the absolutist position? The policy justification, pressed again and again by Ms. Prout yesterday, is that the relevance of a subjective factor known only to the data subject prevents a controller having legal certainty. And what she means by that, and she said this expressly a number of times, that the certainty that the consenting processes they set up will always be adequate in every case. 100% certainty. Anything else is unworkable, she says. And it is, she says, fundamentally wrong for the judge to have identified and permitted, on her approach, an ineradicable risk of cases in which consent will not be valid. Now, I accept the judge's approach does not achieve 100% certainty. The judge's point was a simple one, on which ought, in most circumstances, to be uncontroversial. Legal risk is always ineradicable. One can never have absolute certainty that a general process or a general policy will apply in precisely the way intended in absolutely every case. That ignores the inevitability of exceptional or unusual cases. And there's nothing unique to the data context in this respect. The judge made the point at paragraph 152, which I know you have seen. She gives examples of of the sort of circumstances in which consent might be invalidated. Some of those examples are similar to the sort of ineradicable risk one sees elsewhere in the law. Not every contract entered into will necessarily be enforceable, whether because the counterparty lacked capacity or varies, or the court approaches the construction of the terms in a way that the parties didn't anticipate, whatever it might be. There are different forms of risk and different forms of tools in which to deal with those things, but there is no ineradicable risk. It's a similar point arises in public law by reference to the non-fettering principle. You can have a general policy that looks like a rule, but you have to recognise the possibility of exceptions which require a different approach. And my learned friends say this ineradicable risk is contrary to legal certainty, and there's obviously no dispute that legal certainty is an important aspect of legal policy and of the rule of law, but so is flexibility and the importance of doing justice in individual cases. Many areas of the law do not admit of absolute legal rules providing 100% certainty, precisely because it is inconsistent with those values of fairness and justice to do so. And that's certainly true of data protection law. So it is always possible that no matter how well designed and how considered your processing is, that there will be some particular case, some particular context in which it turns out that it is a disproportionate pursuit of the controller's legitimate interests, applying the Article 6(1)(f) legitimate interest balance.
Well, you're mixing up two different things, aren't you? At the moment we're talking about consent.
We are.
Not other lawful bases for processing data. So let us suppose that the service provider knows that the data subject is a vulnerable person.
Yeah.
It's a problem with gambling. And the system is designed so that you have to tick several boxes in order to give your consent to receiving direct marketing. And the service provider, believing that the person who's ticked the boxes has a gambling addiction, rings them up and says, "Are you sure you want this?" And he says, "Yes, I crave it." What is the service provider going to do? Say, "Well, he can't have it."
Well, I was going to come on to this point as my fifth point, but I mean, the punchline is the way in which the judge's approach is to take all of the factors into account in context. And so the more the controller has done to address the particular area of risk, and the more the risks have been drawn to the attention of the data subject, and the greater the quality of evidence that the data subject has thought about it, then the more likely it is that the balance will favour the controller's position that consent is valid. And so in that context, where you've taken the trouble to specifically speak to the data subject, I'm not saying that is required in this case, but say on that factual analogy, then the outcome may well be different. The point I'm making under this head, and I agree, of course, this case is about consent. But my learned friend's case is that the data protection regime for controllers is designed to ensure that they have absolute certainty about the legality of their processing. And the only point I'm making at this stage is to say that's not how the regime works, and it can't be how the regime works. I gave you the example of the legitimate interest balance. There was some discussion yesterday about the very broad concept of fairness in the first data protection principle. That always has to be considered by reference to the position, the facts of an individual case. And I agree, it's considered on an objective basis. But that's not my point for present purposes. For present purposes, it's sufficient to say that no matter how carefully you've thought about it, there is always the risk that a particular case will lead to the regulator or court or whoever it might be determining that in this case, the processing was not fair and it was unlawful. So there's no reason why, and this is really the punchline submission, I suppose, of this section, why consent has to be different. Why should consent be the subject of an ineradicable risk with 100% certainty? And that's not how the rest of the law works, and it's not how the rest of the data protection regime works. I agree, of course, that the burden is on the controller. Positive part of our case below and here. Well, that's not problematic for this analysis or for the judge's approach, because one does have to consider how is this issue going to arise when one is considering the complaints about it. So the data controller does everything that it can do, having regard to its particular processing context, so that it is confident that it can prove consent on the applicable standard. It's got a baseline. It's done its processes, it's thought really carefully about making sure that they're transparent and everything's severable and so on and so forth. They've done all the objective things. The issue is only going to arise if a data subject comes forward and says, oh, hold on, I don't consent and I didn't consent. And it's not really a question of burden, but it's then going to be for the data subject to consider whether it accepts what the data subject says, gives rise to an exceptional circumstances. Exceptional circumstance that means the overall balance suggests that consent was not freely given. Or if it doesn't, it's not prepared to accept what the data subject says, and it's prepared to defend its position before the regulator or the court. And my learned friend was fond of contractual analogies yesterday, and that's not really very dissimilar to the idea of a contract with an incapacitous minor being voidable at the minor's discretion. It's dependent that the starting point is, if you've done everything objectively, then you assume it's valid, and it's for the person who says the otherwise to come forward and say why. And that's, there's no particular practical or burden problem which arises from it. And so we say the absolutist position pressed on you is undesirable, and it is not justified by reference to an unrealistic policy aim of absolute certainty. The fifth point, to go back to my Lord Justice Lewison's question, which is obviously a question which arises in this context, is, well, how does the controller best protect themselves? And that is not a question that the judge ignores. She addresses it, for example, at paragraphs 180 to 181 on page 113. Again, passages you've gone through, I know. But the essence of that point is that the controller knows the context in which it is processing, and the context, the likely context of the data subject whose data it is processing. And I'll show you some passages in the European guidance that emphasises the importance of that. And so the better you design your objective consenting processes by reference to the legal standards, the smaller the possible cohort of exceptional cases. And through that careful design process, and the judge says this in terms of paragraph 180, the controller will be able to ensure it's obtained valid consent in the overwhelming majority of cases, perhaps nearly always, she says. And to some extent, that is borne out by the fact that this is the first case in which this point is seriously tested, or at least that anyone knows of, it's been reported. But the degree of risk will arise contextually, so the more potentially harmful the processing in question, the more that is required of the controller. The more that going beyond the minimum standards may be necessary. You may need to be more specific, more clear. You may need to present your information in a particularly neutral way. Avoid any risk of influence and so on. That's the sort of contextual standards that the judge is considering, and she goes through in more detail at paragraphs 186 to 199 that I'm going to come back to when I address you on the judge's approach. And of course, it's important to bear in mind, and I'm going to come back to this, you've got this, I'm going to make this point from my third overall submission. In this case, there are clear findings the judge did not consider the objective consenting processes adopted by SBG to be sufficient, but she also makes clear in paragraph 203 of her judgment that the overall balance, notwithstanding the subjective position of RTM, is a finely balanced one. So on balance, and it may be a fine balance, she finds consent wasn't valid. And the indication of that is that she isn't expecting the controller to have to do very much more to address the issue and to tip the balance the other way. This is not an unfixable situation. It's not ineradicable, but it can be reduced more and more the more the controller does. And that point, that reference to context, the importance of the context of the processing is at least common ground. As repeatedly accepted yesterday, context is relevant as it always is, and the nature of the duties will take their colour from that context. And none of that means, as the Commissioner began to float yesterday, and I know was explored slightly in a question from my lady, the President, that data controllers need necessarily to start detailed explorations into the personal circumstances of every data subject. It might mean that in riskier processing contexts, they should be conveying clearer warnings. They should be doing more to make sure the information they give is unignorable, to use a phrase the judge uses. But it doesn't necessarily mean they need to collect more data. But there are contexts in which that is the appropriate approach. That is, for example, and we'll come back to this when looking at the legislation, that is what Article 8 of the GDPR requires in relation to child users of information society services. It's effectively requiring a form of age verification exercise or parental verification. And indeed, then a friend touched on yesterday, and the judge notes by in passing, that is what the regulatory scheme for gambling now requires. Licensed gambling, remote gambling operators are required now to, for example, conduct affordability checks as part of the assessment of whether or not a customer is a problem gambler. So the minimum standards change, and there is nothing inherently problematic about requiring that in particular circumstances. That's not a requirement in all cases, but it's not inherently problematic either. It is contextual.
Just a short point on that.
Yeah.
Does that new element of the remote gambling scheme affect the lawfulness of the processing if it's not complied with?
Well,
Do you say it fits into the consent box?
Well, obviously, consent. Well, both. Yes, I mean, obviously, consent is an aspect of lawfulness. It will be part of the context for assessing consent as to whether the gambling operator's processes are compliant with the regulatory standards. Now, that's in a data protection case. It is unlikely to be appropriate, and that's not what was done here, and this is why the judge doesn't make a specific finding in this way. Unlikely to be appropriate to say you are in breach of social responsibility code provision X, because you don't have private law rights of action to enforce gambling scheme.
I find it difficult to see why, whether somebody has consented should be dependent on whether they're a millionaire or a pauper. I can understand that if you know the consent has been given by a pauper, it might not be fair to act on that consent. I don't at the moment see why it vitiates the consent.
Well, it's part of the picture about how risky your processing is. So, effectively, the point really boils down to this, I suppose, that the more informed and effective your risk assessment models are, and whether that's because you're doing what the regulatory requirements are requiring of you, or you're going beyond those and doing more, then that is part of the context as to what level of risk there is that there is a material cohort of people you're not recognising. The better your systems are, the smaller that cohort must be.
But why is that not, so to speak, in the fairness box rather than the consent box?
Well, I say it is part of all of the most obvious way it's part of the circumstances because it goes to the imbalance in the potential imbalance in the relationship between the data subject and the controller. I entirely accept that it could also go to fairness. I mean, the usual way in which fairness inevitably overlaps very significantly with the particular processing condition that is then relied on. So you usually see it, for example, in legitimate interest cases, in which basically the exercise is more or less exactly the same. So there's a balance between different rights and interests and the overall public interest. the exercise will overlap with the sorts of circumstances and factors that are relevant to the context of the consent analysis. That's not problematic or surprising, we say. Sixth and finally, by way of overall pointer very briefly, the court will of course need very little reminder of the basic principles emphasising the limits of the role of an appellate court, and I take that lightly, partly because of course I recognise that ground 2 is in significant part a question of law for an appellate court, but there are aspects of ground 2 and certainly of grounds 3, 4 and 5 to which the warnings about evaluative judgments, about evidential consideration and findings by the trial judge, and my Lord Justice Lewison's warnings about evidential island hopping on appeal. There is some relevance to all of those things at stages of the analysis, but I take those lightly at this point. Can I move on then to deal with the law on consent and the role for subjectivity? I'm going to address here first the purpose of the legislation, second the language of the legislation, third the European guidance, which wasn't opened at all before you yesterday, and fourthly to come back briefly to address Cooper. So first, on purpose, 3 points on purpose. First, common ground and trite that all legislation, domestic and European, is to be interpreted by reference both to the text and the purpose. Relatively little focus yesterday on the purpose, but the purpose of this legislative scheme was summarised by my Lord Justice Warby very recently, a few weeks ago, in this court's judgment in DSG Retail and the Information Commissioner. And you have that judgment at tab 25. If you've got hard copies, the final tab in the first volume, tab 25, page 580. And that judgment sets out, which I'm sure is common ground, the general approach to interpretation, including by reference to text, context, purpose, consequences, and so on, for present purposes. And it's a case principally about the 1998 Act and the 1995 Directive. Can I just invite the court to read paragraph 51 on page 595. And the central submission I make on the purpose of all of the legislative schemes here is that their core purpose, with which paragraph 51 encapsulates and is consistent, is to protect the fundamental rights of individuals, and particularly their privacy rights and data protection rights. And that is not just derived from the recitals. The European instruments, in the usual European way, have in Article 1 of each of them a statement of the purpose of the regime, and in each of them they say in terms, For example, Article 1.1 of the 1995 Directive, tab 6, page 72. In accordance with this directive, Member States shall protect the fundamental rights and freedoms of natural persons, and in particular their right to privacy with respect to the processing of personal data. You don't have the equivalent Article 1.1 of the e-privacy directive directly, but it's set out in Planet 49, paragraph 8 of the CJEU's judgment, just for your reference, tab 26, page 630, very similar form. And you weren't particularly asked to look at this yesterday, so I'll show you in terms. The GDPR is again no different. And to use, I think, the version that you had added to the back of your bundle yesterday, page 1173, Article 1.2, Article 1.1 and 1.2. This regulation lays down rules relating to the protection of natural persons with regard to the processing of personal data, rules relating to the free movement of personal data. This regulation protects fundamental rights and freedoms of natural persons, and in particular, the right to the protection of personal data. And you have seen yesterday recitals 1 and 2, which make that point in at slightly greater length. And you looked briefly yesterday at recital 7 on page 1168. And the emphasis was placed before you on the final sentence about legal and practical certainty being enhanced. And I agree, but it's important to read the totality of recital 7. What is this regulation for? It's to require a strong and more coherent data protection framework, backed by strong enforcement, given the importance of creating the trust that will allow digital economies to develop across the internal market. Natural persons should have control of their own personal data. And then the sentence about certainty. And the recitals, and indeed the entire scheme of the regulation, talk about how the legislation sets out the rights of data subjects and the obligations on the controller. And that is how the GDPR is structured. It doesn't afford rights to controllers and imposes no obligations on data subjects. None of those starting points say or mean that data protection and privacy rights are absolute. They clearly aren't. The regime as a whole is a calibrated one, but the core starting point purpose of the legislative regimes is to strike those detailed balances, that balance in a detailed way to ensure that an appropriate degree of protection is provided. It is fundamentally a protective regime. Secondly, follows from that, we say that core purpose should illuminate a key absence in SBG's analysis. Because the submission of SBG, and to some degree the ICO, was in terms that consent must be looked at from the lens of the controller. But the person this legislation is protecting, the person whose privacy is in issue, is not the controller, it is the data subject. It is simply inconsistent, in my submission, with the core purpose to advance this entire analysis through the interests of the controller and the impact on the controller. Doesn't mean those things are irrelevant, but they are not the focus. And it's important because one might have come away yesterday thinking that the point of the data protection regime was to protect the position of controllers, to enable them to contribute to the economy. That was Ms. Proops's emphasis, and that is back to front, we say. And that's all the more obvious where the concept of the regime in issue is consent. Because of all the lawful bases for processing, consent is the one which is inherently data subject centric. It's about what the data subject does by reference to a test very clearly set in terms intended to protect the data subject and give them control. It is, I agree, an intrinsically relational process, but the data subject must obtain consent from the data subject. There are two parties, yet it is the position of the data subject, one of those parties, their understanding and experience, which my learned friends say must be excluded altogether from the analysis. In contrast, the data controller's understanding and experience is central and indeed total. And I'll come back shortly to the European guidance to show you there the data subject centred approach to consent is very much the theme of that guidance. A further point, the third point on the purpose of the scheme, by reference to some provisions you didn't see yesterday. Ms. Proops showed you recital 47, I think, in the GDPR, setting out that direct marketing is specifically referenced as a legitimate aim of controllers. We've always accepted that. But recall, this appeal concerns the PECA regime in particular, direct marketing by email and the use of cookies. You've been shown regulations 6.2 and 22 of PECA, implementing the privacy directive. And the legislative judgment at both European and domestic level is that those are interferences with privacy which can only be done on the basis of consent. That's the legislative policy, and it is, we say, a conspicuously protective one, notwithstanding, in principle, the legitimacy of direct marketing as a processing activity. And what is more, and these are the provisions you weren't shown, the data protection regime provides for a further specific protective rule in relation to direct marketing processing. And the shortest way to show you this is in the judgment, because the judge quotes the provisions at page 75. At paragraphs 38 and at 40, the judge quotes the provisions from the 98 Act and the GDPR which address the data subject's right to object to processing. And in both regimes, in section 11.1 and in articles 21.2 to 3, the legislation creates an absolute right of the data subject to object to direct marketing processing. And if that right is exercised, it must stop. No exceptions, no defences, no balance. And what that tells you, we say, is that the legislation is particularly concerned, the totality of the scheme, particularly concerned to emphasise a balance in favour of the data subject in the context of direct marketing. The data subject should have control. The interest in direct marketing on the part of the controller is legitimate, but not, as is clear from these provisions, legislatively considered to be a particularly weighty one. And that is perhaps relevant when one considers the point SBG advances on this appeal, but not before the court below, that direct marketing engages Article 10 rights in a material relevant way. The legislation reorientates the focus very carefully and in support of the data subject, and that is relevant to when one is approaching what consent means in this context. Can I turn then to language? Six points on the linguistic indicators from the regimes, and I say at the outset, no party is going to be able to point to you clear and unambiguous language in any of the legislative regimes which is a knockout blow on the subjectivity issue. My learned friends yesterday obviously pointed you to various bits of the language they say emphasises an objective approach, and I'm going to show you some language which I say is consistent with a role for subjectivity. but no one is suggesting, I don't think, and I'm certainly not going to suggest to you, that the construction exercise is unambiguous. That is, of course, why I start these submissions by reference to purpose, and why my learned friend didn't. So the first of the 6 points is that it is no part of my case, and I say no part of the judge's approach, to suggest that consent is a wholly subjective analysis. And that point seemed to be the case that Miss Emerson was arguing against yesterday, but that's a straw man. It is plainly correct that there has to be an objective, clear and affirmative indication of consent. That's what Article 411 says, what Article Recital 32 says, similar wording in the predecessor legislation. And that is, of course, a reflection of the need for workability and for the controller to be able to show consent. So I entirely accept that the language requires objective elements, but that's not the totality of the answer, because the submission that has to be made out by my learned friends is that there is no role for subjectivity. Secondly, I broadly agree with Miss Emerson that some of the elements of the test are essentially objective. So the requirement that it be unambiguous is sensibly an objective question, and specificity is also likely, realistically, to be objective. And she was right to say, and I'm going to come on to this in a bit more detail in a moment, that the condition of freely given consent is the element that's most obviously susceptible to subjective considerations. Where perhaps we part company, or where there is more nuance, is that I don't accept that the requirement that consent be informed is necessarily wholly objective. There is an important objective element. There must be a sort of verifiable aspect of transparency concerning what the data subject has been told and how they are told. But there is case law supportive of the potential relevance of subjective understanding, and which is inconsistent with the Commissioner's submission in response to a question from my Lord Justice Lewison yesterday, that the only thing that matters is if the information is made available. You've seen one bit of this case before, but not all of it, and not the relevant bits. Can I take you back to Orange, Romania, please? Orange, Romania is in tab 27, page 643, and it, like Claimant 49, is a pre-IP completion day judgment of the CJEU. Relevant for my purposes, just to briefly invite you to cast an eye over paragraphs 21 to 25 and the outline of the facts as the CJEU understands them. And in essence, as I talk while you read, if I may, Orange Romania staff Orange Romania was fined by the Romanian Data Protection Authority in relation to its retention without valid consent of customer identity documents. Copies of those documents were annexed to the contracts, effectively for a new phone, and were kept by Orange Romania. Now, the contracts contained clauses that the customer had consented to the storage of the ID document. And you see that at the top of page 649. Some documents, the facts say, had a specific box crossed by reference to that term, some did not. All of the contracts were signed by the data subjects. Now, you were shown, I think twice yesterday, paragraph 40 on 651. And paragraph 40 is, of course, important, and it really repeats what it was earlier said in Claimant 49. What you weren't shown was the next page, and in particular, paragraphs 45 and 46 on page 652. At paragraph 45, the court revisits the contractual clauses and the fact that, as they understand it, some of the boxes were ticked by Orange Romania staff before a general signature was then given by the customer. And then at 46, the court says, if Orange Romania staff tick the box, then that's not a positive indication of those customers' consent. That's the first half of the paragraph. And then importantly, the fact that those customers signed the contracts containing the ticked box does not, on its own, prove such consent in the absence of any indications confirming that that clause was actually read and digested. And that is at least support for the proposition.
Well, isn't that in the context of the fact they hadn't actually ticked the box themselves? Is
Well-
that not the caveat to that?
Well,
Is that the way it looks from that paragraph?
yes, that is of course the context in which that observation is made, my lady.
Since according to the information they do, so that then the question is what happens if the box has been ticked? That's what we're concerned with here.
Well, to some extent that's right, but the proposition as far as I don't put it too far. What I do say is that is at least support for the proposition that evidence as to the subjective position of the data subject, whether they actually read and digested the detail, is relevant to the question of whether consent is informed.
Is this very different from Planet 49, where there's a pre-ticked box? Here, by the time the customer comes to sign the contract, there is in effect a pre-ticked box.
Well, in factual terms, no, that context is not particularly different. What I'm showing you in this paragraph, or this part of this paragraph, is a formulation of words used by the court that is consistent with an idea that what the data subject has actually done, subjectively, whether they have read it and digested it. Digested it is not evidenced solely by a ticked box, we respectfully say, is potentially relevant to the question of consent, and particularly whether the consent was informed. And there's material in the guidance documents that I'm going to come to shortly, which says something similar.
This passage refers back to the Advocate General's opinion.
Yes, and we don't.
I mean, quite often they do quote things literally verbatim, but it's always useful.
Yes, and I'm afraid I can't remember off the top of my head
No.
whether the Advocate General, this is a formulation that comes from the opinion.
No.
I'll check on the shorter check.
Thank you.
I mean, I can put the point this way. It is really the only indication in the CJEU judgments that you have that it is the indication in the CJEU judgments that address the potential relevance of subjective knowledge of some aspect. None of the other judgments address the point either way. Thirdly, the requirement that consent was freely given is, we say, on an ordinary and natural meaning of those words, intrinsically redolent of the data subject's subjective position, not least because that is something that the data subject is best placed to address. And we do say that is consistent. The consistency with subjective relevance is enhanced not just by the natural meaning of the words freely given, but also the formulation of recital 43. And to take you back to, I think, the version you were probably highlighting on 1171. Now, the key reference for present purposes, there are a number of different circumstances in which the legislation addresses freely given. Not some of them are effectively objective about bundling of consent within what is being offered to the data subject. But the key formulation for present purposes is at the beginning of recital 43, and the reference I was picked up upon yesterday to a specific case where there is a clear imbalance between the data subject and the controller, in particular where the controller is a public authority, and it is therefore unlikely that consent was freely given in all the circumstances of that specific situation.
Going back, well, obviously one looks at recital 32 as well, which comes before 43.
Yeah.
Going back to your example of the gun to the head.
Yeah.
and you gave that example in the context of what you call the absolutist position.
Yeah.
If that were to happen, somebody ticked a box, look at recital 32, and data was processed following the ticking of a box. Is your position that will be unlawful?
Yes. I do say that would be unlawful. That would not be consent freely given. I mean, it's obviously an extremely exceptional case. But if in essence, I suppose the position between us amounts to this: that the concept of freely given consent must be able to encompass such exceptional cases, even though the data controller was not available.
You might say the conduct of the person holding the gun would be unlawful, but you're saying that the conduct of the data controller would be unlawful.
Yes, it would. It would be unlawful. It would not have been processed on the basis of it would not have been processed on the basis of consent. Now there may be contexts in which, and direct marketing is not one because of the specific rules of PECA, but in some contexts a data controller might be able to say, well, I thought I had consent, but actually if I didn't have consent I can rely on one of the other processing conditions. So that may be an answer in some cases, but let's assume we are in a direct marketing context, direct marketing by email context, and it has to be consent. That is not freely given consent. Okay. I accept that's the logic of my position. I'm quite happy to stand behind it, and I say it would be more surprising if that was consensual within the meaning of this legislation than if it was said to be wholly irrelevant.
What does freely given mean in this context? I mean, the gun to the head is one very extreme example, but this is not a question of mental capacity, is it?
It's not to be equated with mental capacity, no, because and we know that because the sorts of situations that the recitals indicate are ones that don't come anywhere close to a loss of capacity.
No. How do you judge? What criteria are you to apply?
Well,
I was fed up with so-and-so nagging me to sign up to this.
Well, as I said in answer to my Lord's question earlier, it is a contextual exercise by reference to all of the context of the particular case, and so the more limited the degree to which it can be said that the freedom to consent was realistically affected, the less strong that argument is going to be. So the nagging example is unlikely to be a particularly weighty one in the round. The gun to the head one will be an almost probably insuperably weighty one, and everything else will be somewhere on a spectrum in between. And to the extent that that is not a sort of rules-based answer to my Lord's question, I accept that, but that's because it's a contextual assessment, and that's...
The problem with the contextual approach, as I see it at the moment, is that it doesn't give you a yardstick. You're just saying, here are all the circumstances, and you make an evaluation, but an evaluation of what? Which the answer is whether it was freely given.
Yeah.
Which you're coming back to your starting point. So, for those who have to make decisions about this, either time consent is or isn't freely given, or later, that poses a dilemma.
Well, two answers to that question, I suppose, my Lord. One is, as I will come on to, some further assistance is given by the European guidance documents. I'm not going to suggest those are complete answers to every possible context, of course they're not, but they give some flavour of the sorts of things, the sorts of guidance that go towards a yardstick. The second answer, and it may not be a satisfactory answer, but it's nonetheless a necessary answer, is to the extent that the court is concerned, and this is not a very helpful concept, it's not how we would have drafted it, that's what the legislation says. And that's the concept that the legislation has adopted, and consistently adopted since the 95 directive. And so it's not uncommon for legislation, both domestically and European, to use concepts which are not instinctively easy to assess the totality of, and everyone has to get on. I mean, the same is true of fairness. The same is true of a number of the broad concepts used in the data protection legislation. They are deliberately and necessarily require assessment by reference to context, and that means the outcome of them may not be as predictable as controllers might like.
In that context, let's look at recital 32.
Yeah.
Consent should be given by a clear affirmative act establishing. So how do you approach the issue of freely given in that context?
Well,
You say that how does that assist us?
well, it's part of the picture, and it goes back to the point I was accepting, I think, under my first point here, that there has to be an objective outward manifestation of consent. So, I mean, effectively, that's the starting point. And if one goes back to what I was saying about the submission I was making in the context of the burden, from the point of view of the controller has to do all of the objective things to get the outward manifestation, the clear, unambiguous indication, because we've done the informational exercise, ensure that consent is specific, and done so far as it can to frame the consent it is asking for in a way which allows the data subject to engage in that process in a free manner, mindful of the fact that there may be some contexts in which there are exceptional circumstances in which consent was not free.
The recital suggests, does it not, that it's the affirmative act which establishes the freely given specific informed consent.
Well, I think my submission
That's
on
the very act which establishes what you're looking for.
well, my submission that the natural meaning of that in the total context of all of the language of the recitals and the definition and the purpose of the regime is that means evidence.
That is
Evidence. Can I just? I'm conscious of the transcriber rate. Can I just complete the points on the language of recital 43? And saying, as I say, I'll come back to the guidance shortly. But the language of recital 43 on the imbalance example that it gives, it is a highly fact-specific focus. Repetition of the language of specificity. It's looking at the particular position of the specific data subject, not data subjects generally, and vis-a-vis the controller. So the imbalance has got to be against this particular controller. There is no presumption being applied carefully in that first part of paragraph 43, contrast the second part of paragraph 43, recital 43. And that's because it's inherently fact-specific. And that's obvious, that might be thought obvious why. To take the employment example, a new cleaner signing up to an employment contract may well be subject to a very clear imbalance. A new CEO may not. But I would particularly emphasise the language freely given in all the circumstances of that specific situation. And my learned friends say all the circumstances doesn't in fact mean all of the circumstances. It means all the circumstances of which the data controller is aware or is constructively aware. And my submission is that's not what the language says. And just finally on this point, there was a question yesterday as to what clear means in this sentence of recital 43. And we say clear means a significant imbalance. And not simply a marginal or a slight imbalance. That's purposively what this part of recital 43 is addressing. If that's a convenient moment to pause.
It would presumably be an imbalance which is known to the data subject, otherwise it would have no influence in whether or not the data subjects consent.
Yes, I agree with that, my lord, and indeed for the further practical reason that if the data subject doesn't know it, then it's very unlikely to ever arise. Not the data subject's not going to subsequently rely on it.
Right. 5 minutes.
All rise in favour?
You're right, yeah.
The live stream mics are the one thing for this evening, so nothing sort of changed. Yeah, those are the transcriptions. Yeah. I think that's alcohol. Just do down
Three different salads, you get 3 salads with the roast.
That's like a roast.
It was a roast, it was great.
Is it the place that has the temptation?
Yeah. That was exactly what I needed. It's chewy. I did do a little bit, yeah.
All rise in favour.
My lady, I promised or perhaps threatened you with 6 points on the language, and I've done 3. So point 4 is to pick up a point my Lord Justice Warby made yesterday, which wasn't really then followed up. But we do say there is some importance to be derived from the way in which consent is presented in the legislation as a lawful basis. And that is in Article 6.1 of the GDPR, although it's in exactly the same format in the directive and under the 1998 Act. So Article 6.1 begins at the very bottom, slightly unhelpfully, of page 1179. Processing shall be lawful only if and to the extent that at least one of the following applies. And then over the page, 6 sub-bullet points are then set out. And all of B to F are framed in the same way. The processing must be necessary for the specific context, be it contract or legal obligation. And that language of necessity, the case law, which we've not troubled you with, but establishes, conveys an objectively assessed balancing exercise. And they're all matters that arise from the position of something that the data controller wants or needs to do. A contract with the data controller, a legal obligation on the controller, something the data controller wants or needs to do to protect the data subject or a third party, a power of the data controller, the legitimate interests of the data controller or a third party. The contrast then with the framing of subparagraph A. The data subject has given consent. That is data subject centred, not data controller centred. It is by reference to whether the data subject has given it, not note, language which might be much more consistent with my learned friend's submissions, whether the data controller has obtained consent. That would support my learned friend's analysis. That's not what this says. And as I say, Article 7 of the Data Protection Directive is framed in almost in materially the same way. Page 74 of the authorities, same in Schedule 2 to the 1998 Act, page 31 and following of the authorities. The fifth point is the Regulation 30 sub 2 point from PECA. Regulation 30 sub 2 is in Bundle 1 of the authorities, tab 2, page 60. And and you saw that yesterday. And we say the judge was with respect right to note the relevance of this provision where processing is based upon consent, where processing based on consent is regulated by PECCA, as in the case of cookies and email direct marketing, which was the focus of what she analysed in the judgment. And Regulation 32 provides a reasonable care defence to a compensation claim for breach of PECCA. And as the judge noted at paragraphs 169 and 192 of her judgment, the very existence of that defence and the expressly objective terms in which it is drafted is an indication that the legislature in PECCA recognised that there would be cases in which objectively reasonable care had been taken, but that there was still not valid consent. Quite hard to see what the purpose to Regulation 30 sub 2 would otherwise be. And the solution of the legislation is not to deem that there was consent in such circumstances, because that, we say, would undermine the privacy purpose of the scheme, but rather to limit the remedial consequences on the controller. And my learned friend says, well, it doesn't render the processing lawful, and it doesn't. But that's consistent with the wider legislative policy that I showed you in section 11.1 and article 21 of the GDPR, that there's an absolute right to object to direct marketing.
Is Regulation 30 a requirement of the directive, or is it one of those optional extras that you can have?
Well, so the answer is half and half, my lord. You have, as it happens, a version of the Privacy Directive that is unamended. So a subsequent amendment to the Privacy Directive inserted a requirement that there be a right of compensation. The reasonable care defence is not a requirement of the directive, either originally or as amended.
So that's a domestic add-on.
It is a domestic add-on.
How does a domestic add-on inform the interpretation of pan-EU regulation such as the GDPR?
Well, it recognises it recognises the effect of the interpretation. I'm not saying it drives it. I'm saying it's addressing its consequences, and it is important to note because Ms. Proop said, well, PECCA can't wag the PECCA tail in this respect can't wag the GDPR dog. What she didn't mention is that Regulation 30 sub 2 of PECCA has a direct counterpart in the same terms in the 98 Data Protection Act.
Again, not in the directive.
Again, not in the directive, but again, a reasonable care defence in the ability to claim compensation in section 13.3, which you have at page 6 of the authorities bundle for your note. So there was a consistent approach across both regimes applicable to the first part of the period relevant to this claim, which provided a remedial answer to a controller faced with an exceptional case where a subjective mindset was a weighty factor. Now, I quite accept Ms. Proops's further point that the EU has not made an equivalent provision, at least not in clear terms, in the GDPR. I'm not sure that it's necessarily right that Article 82.3 is impossible to read in a similar manner, but that's not a case that you need to determine for present purposes. But in any event, as you saw from Recital 7, amongst other places, one of the purposes of the GDPR regime was a general strengthening of it and the enhancement of the rights of data subjects. It is also right to say that, to some degree, that point is not directly relevant to these findings because they are focused on PECCA breaches, to which Regulation 30 sub 2 is in principle available. Sixth, and finally for this section, my learned friend now praised and aid orally Article 8 of the GDPR and the specific treatment of child consent. I don't think I particularly need to go back to the precise terms of it, but that is ultimately, we say, a point against her and not in her favour. Because what that shows is that the problem of the specific problem of consent of child users to information society services, and that is the only context in which Article 8 applies, was thought a sufficiently widespread issue in the development of the online age and social media platforms and so on since the 95 directive, that specific legislative treatment was needed to address how the balance of responsibilities between data subject and data controller was to be struck, and to legislate for a specific role for parents in that context. What it in effect does is a specific form of deeming provision about consent being valid if the data controller has taken reasonable efforts to verify parental consent. And again, specific use, deliberate use of reasonable efforts, in contrast to the language elsewhere. And what that reveals, we say, on classic interpretive principles, that this intervention was required in the first place precisely because the general approach to consent would not otherwise apply in this way. And so this particular provision strikes a specific balance in a specific context. But if Ms. Proops were right, that's precisely how all of the other provisions of the legislation should be adopted, then at least some aspects of Article 8 might be thought to have been surplus to requirements. And of course, as I said, continues to leave all other issues which might bear upon the ability of the data subject to consent freely to the ordinary approach under the regime. So Article 8, we say, doesn't take matters very much further, and to the extent that it is relevant, it is a point against my learned friend and not in her favour. I have repeatedly promised you that I would show you the European guidance, and that is the next set of my submissions, if I may. A particular admissible aid to the interpretation of these regimes comes from the guidance of the pan-European body created under the Data Protection Directive, under Article 29 of that directive, and then renamed under the GDPR as the European Data Protection Board, with a specific legislative function of giving guidance on the terms of that legislation. So the Article 29 Working Party and then the EDPB. And the principles are collated by reference to authority, just for your note, in the Upper Tribunal's judgment in Experian and the ICO paragraphs 91 to 94. And that is tab 20 of the authorities, page 415 to 416. And that approach is, unsurprisingly, that what the guidance says is not determinative, but it is a weightier aid to construction than academic commentary, because the people giving it are exercising a specific function in giving that opinion in order to enable consistent application across Europe. Both of those bodies, the Working Party and then the Data Protection Board, are made up of the national data protection authorities from the member states. So prior to Brexit, the Information Commissioner was a member of both entities. If I can give your ladyship and your lordships the propositions I draw from these materials up front, and then I'll show you the most useful or the most relevant passages on the subjectivity question. All of them, they are consistent with and they further the privacy protective purpose of the scheme. And in my submission, the materials show first that the standard of consent is an exacting standard and deliberately so. Second, that consent requires a highly fact and context-specific analysis informed by the specific processing, specific controller, and specific data subject in issue. And that may cash out in precisely what must have been done to ensure that the data subject was relevantly informed about the processing, but it may also affect analysis of whether consent was freely given. But it is not, from the guidance, an exercise simply to be considered from the controller's end of the telescope. Third, matters subjective to the data subject are not excluded. On the contrary, the guidance, and I accept at the outset, the guidance doesn't address this issue in terms, either way, but it is strongly consistent with such factors being of potential relevance in some contexts. Much of what is said in the guidance can only coherently be understood if it is a recognition of the relevance of the subjective position of the data subject, and particularly as to whether or not consent is freely given. Fourth, where the GDPR has developed the law on consent, and in particular some of the concepts referred to in the recitals, which are not referred to in the recitals to the directive, you'll see that it has done so reflecting established guidance of the European regulators as to how the predecessor regime should be interpreted and applied. So really what the GDPR does is draw together those concepts and reaffirms them rather than doing anything particularly radically new. There are two guidance documents I particularly want to take the court to. I do invite the court, subject to the court's patience, to read the totality of them at your, in inverted commas, leisure, but I don't intend to try anyone's patience by taking you through the totality of them orally. The first is at tab 33 of the bundle, page 855. And it is opinion 15 of 2011 on the definition of consent from the Article 29 Working Party in July 2011. So predating everything relevant to this case. And to jump ahead slightly, is expressly adopted and endorsed later under the GDPR. The purpose of this guidance, these guidelines and this opinion, is summarised in the first paragraph on 857. And the one sentence summary of that first paragraph is that the working party is seeking to create a consistent approach across the EU.
So are you starting at 857?
Yes, first paragraph under introduction. Am I in the same place as your lecture?
Yes, no, I was just reading on 856 before you get there.
Yes, 856 is a sort of general summary, and I wasn't going to take you the course.
No, I was just looking at no doubt you'll deal with this, but what's said in Little Roman 1 on 856.
Yes, well, that I don't take any issue with that. I mean, that reflects the point I made, I think, under the second point on the legislative language that the requirement of unambiguous consent must be an objective.
You want us to go to 857?
Yes. So the first paragraph under the heading introduction on 857 just explains what the opinion is seeking to do and why it is seeking to do it. 862 to 863 under the heading control. Again, I don't want to read that passage out. It's about 3 paragraphs long or so, but it is an emphasis on the consent has its basis in notions of control, informational self-determination and autonomy. And of course, all of those concepts are very redolent of the judge's analysis. That's why I show you those passages. None of these concepts are coming out of the clear blue sky in the judgment. And then 866, bottom of 866 is where the discussion of freely given commences. And the first sentence summarises freely given as being, consent can only be valid if the data subject is able to exercise a real choice, and there is no risk of deception, intimidation, coercion, or significant negative consequences if he or she does not consent. And that is a formulation we say consistent with our approach and the judge's approach. Page 867, a particular example that will impede freely given consent is given of the employment relationship. See that at the first full paragraph on 867. And the working party emphasised that in this employment relationship example, not necessarily always, the data subject can be in a situation of dependence on the data controller due to the nature of the relationship or to special circumstances, and might fear that he could be treated differently. We say that's consistent with the relevance of the subjective position of the data subject. At the very least, it is consistent with a highly fact and context specific analysis. Lower down the page, the working party quotes a previous opinion from itself on electronic health records, and in the quotes a passage in the italicised text. Free consent means a voluntary decision by an individual in possession of all of his faculties, taken in the absence of coercion of any kind, be it social, financial, psychological, or other. And that is a passage we say only consistent with the potential relevance of the subjective position of the data subject. 868. Below the there's an example box there of a situation in an employment context where consent might be valid because it's particularly carefully approached.
So where are you in 868? The sideline bit.
No, just level with just below the text box.
Context of employment.
Context precisely. I was just saying that the text box is an example that they give where consent could be valid in the employment context. I wasn't particularly inviting you to read that, but below that, the context of employment requires specific discussion. The cultural and social aspects of the employment relationship play a role here. And then the passage below the bullet points, although there may be a strong presumption that consent is weak in such context, that doesn't completely exclude its use, providing there are sufficient guarantees that the consent is really free. While a situation of subordination is often the main reason preventing consent to be free, other contextual elements can influence the decision of the data subject. They can have, for instance, a financial dimension or an emotional or practical dimension. And again, same submission, closely reflective of the approach taken by the judge. And then the guidance goes on to consider the particular position of public authorities as controllers, and emphasises, for example, on page 870.
The examples given on page 869 are all things which the data controller is doing.
Yes. Well, as I said at the outset, my lord, I'm not. The points I take from this guidance are consistent with my submission, but I don't put the case higher than that. There are lots of phrases that are consistent with, and in some cases only really consistent with my interpretation, but they don't give a specific answer to the specific question that you are grappling with, including in the examples. I give away that punchline at the outset. And to complete the references here on public authorities, 870, middle of the page, just a paragraph just above the e-government example, a careful check should be performed on a case-by-case basis to assess whether consent is indeed sufficiently free. Again, all consistent with the submission I was making to your lordships and your ladyship, in which, for example, the court was considering with me whether that was really the right approach to consent. Those are the passages I particularly wanted to highlight out of the 2011 opinion. A boring point, but just for completeness, given the time period of the claim, at 893, tab 34, the Article 29 Working Party issued guidelines on consent under the GDPR in 2017, so relevant to my client's claim, but in anticipation of the GDPR coming in force, so there's still the Article 29 working party then. That those guidelines were then re-adopted in the next tab, at tab 35, page 924, by what had become the European Data Protection Board, guidelines 0520, adopted on May 2020, and I'm going to show you this version, but principally because it's got paragraph numbers and therefore it's easier to show you the passages I want to show you. The content is expressly almost exactly the same as the version of the document you have at 893. And they say that in terms 927. This document is a slightly updated version of that of those earlier guidelines, and the specific examples are not, the specific changes are not relevant to our case. So that is what I'm doing for the sake of form. Page 928, paragraph 4, that is the point I made earlier, that the EDPB under the GDPR is reiterating that the 2011 opinion I've just shown you on consent remains relevant, as the GDPR codifies existing working party guidance and general good practice, and most of the key elements of consent remain the same under the GDPR. So there's a consistency of approach throughout. Page 930, paragraph 11 summarises generally the requirements of consent, and then from paragraph 13 onwards addresses the requirement that consent be freely given, and invite you to read in due course paragraph 13, in particular in the second sentence, the reference to if the data subject has no real choice or feels compelled to consent.
Sorry, where were you reading from there?
Paragraph 13,
Thank you.
second sentence.
Right, behind you.
Or will endure negative consequences if they do not consent. And we say, as you would anticipate, it's very difficult to see how an assessment can be made of whether or not a data subject feels compelled without a close investigation of their circumstances and the effect of those circumstances on them, as the judge does in the case of RTM in her judgment. Over the page 931, paragraphs 16, 17, 21 and 22 are all about the imbalance of power issue, and the point generally to be drawn from those paragraphs, and indeed the example text boxes in between, is that the board is making clear that there's no total exclusion of consent in the public authority context or in an employment context. The language is consistently general, so it is looking at the situation will often arise, but it's unlikely that consent will be valid. Consent will be problematic, but it may, paragraph 22, be possible for the employer to demonstrate that consent is actually freely given. And all of that is reflective of a necessarily highly fact-specific analysis and assessment. Paragraph 24, foot of 932, imbalances of power not limited to public authorities and employers. And final sentence, consent will not be free where there is any element of compulsion, pressure, or inability to exercise free will.
But in the context of imbalances of power, that surely means compulsion, pressure on the part of the data controller and inability to exercise free will caused by something that the data controller has done, or the relationship between the data subject and the controller.
Yes, that is undoubtedly the focus. The point, the 2 points that we draw from that formulation are, one, highly fact and context specific, and second, even in the context of a relationship between a data subject and a data controller, excluding anyone else, it's difficult to see, we say, how you can properly assess elements of compulsion, pressure, or an inability to exercise free will without having regard to the subjective mindset of the data subject. Even if it is vis-a-vis the controller specifically. Can I jump forward to page 938, please? And there, the guidance is addressing the minimum requirements for consent to be informed in paragraph 64. And then over the page 65, and the final sentence of paragraph 65, got a point I don't think is really in dispute, but we've touched upon it at various points this morning. The EDPB notes that depending on the circumstances and context of a case, more information may be needed to allow the data subject to genuinely understand the processing operations at hand. So you may be required to be able to say consent is informed to go beyond the minimum standards to meet the consent requirement. And that contextual point is particularly emphasised in paragraph 70. A controller must assess what kind of audience it is that provides personal data to their organisation. For example, in case the targeted audience includes data subjects that are underage, the controller is expected to make sure information is understandable for minors. After identifying their audience, controllers must determine what information they should provide and subsequently how they will present the information to data subjects. Again, a point I've made and ought to be one of common sense, but precisely how you comply with the consent standards is contextually specific to the controller's processing, and who the controller expects its data subjects to be. 939, paragraph 74, and this is example 13. I want to show you this because it goes back to the point that was made in paragraph 46 of Orange Romania. So example 13, and this is in the context about the requirement of consent being informed. The company uses a layered privacy notice. It discloses, the example is that the company discloses all basic details of the controller and the data processing activities, i.e. the core minimum information in the first layer. However, the company doesn't indicate how their data protection officers can be contacted in the first information layer of the notice. And the guidance says, well, that doesn't infringe the requirement to be informed because you've got the most important things at the outset. And I wanted to draw to your attention footnote 42. Note when the identity of the controller and or the purpose of the processing, i.e. the core minimum information, is not apparent from the first information layer of the layered privacy notice, but are located in further sublayers, it will be difficult for the controller to demonstrate that the data subject has given informed consent, unless the data controller can show that the data subject in question accessed that information prior to giving consent. Now, that's not necessarily subjective evidence. It could be, it's consistent with that, but it's certainly consistent with a highly fact-specific, data subject-specific exercise. I fully accept, for example, that a reading of that footnote, one way that a controller might be able to do that is that it can show from its data analytics that a particular data subject clicks through the different layers of the privacy policy. And indeed, if you go to that effort, it's almost certainly because you are in fact reading it. And you'll be able to show then that you were the data subject was informed, even though the most important information wasn't unignorable in the first section. A similar point is made in paragraphs 87 to 88, page 942. It's not open to data controllers simply to say or people don't read this stuff, people don't read the privacy information we give them, there's click fatigue. If you want, I mean, effectively, and I'm very much paraphrasing, but the message of 87 to 88 is if you want to rely on consent, that it is your problem to address that. So those are the points I wanted to particularly highlight to you from the EDPB guidelines. Given yesterday's submissions, I just wanted very briefly to show you a couple of passages in documents issued by the Information Commissioner. So at tab 36, you have the Commissioner's consent guidance from 2022, beginning at page 957, page 970 to 971. The Commissioner is there discussing whether consent is freely given, and in particular whether the controller is in a position of power over the data subject. And there are examples given that the court can read, and the text in the middle of 971. You need to look carefully at the particular circumstances and be confident you can demonstrate that the individual really does have a free choice to give or to refuse consent. You may need to take steps to ensure that the individual does not feel any pressure to consent and delay any concerns over the consequences of refusing consent. That is a highly data subject specific approach, and again, has to be informed by the data subject specific mindset. This is about evidencing it, but it appears to suggest that in some circumstances you need to engage directly with how the data subject is specifically feeling in order to be able to show valid consent. A similar point is made in the Commissioner's consent or pay guidance, page 939, tab 939, page 1105. And the vast bulk of the particular concept of consent or pay, which is about the degree to which controllers are entitled to offer a choice to data subjects between consenting to the use of their personal data or having to pay for a form of the service. Is that alternative a detriment to them that undermines the validity of their consent? But there is some specific commentary in page 1124, again in the context of a power imbalance.
What was the page?
1124. Mr. Emerson, I think, is asking you to also read 1123. I was very happy for you to do so. The point I was going to draw to your attention in 1124 is a reference in the first bullet point towards the bottom of the page. Some groups of people may be in a more vulnerable position, e.g. due to their age, disability or financial situation. It could have a greater impact on their ability to refuse or withdraw consent without detriment, particularly relevant if your product or service is intended for children who are unlikely to have the financial independence to freely give consent within a consent or pay model. Not directly addressing how the controller is to establish or consider those points, but the reference to their relevance is perhaps instructive in the context of this wider debate. So those are the guidance documents. I don't repeat the submissions that of the points I draw from those that I gave you at the outset, but I do say their content, while not determinative of the issue, is supportive of the approach of the judge and the submissions I am making to you, and in some respects only supportive of that. The final head under the law on consent is the judgment of the Court of Appeal in Cooper. I will go back to now, if I may. Cooper and the NCA. Tab 15 of the authorities bundle, page 256, please. Bundle 1 if you are using hard copies. And this is the only real authority prayed against me and prayed against the judge. The context of Cooper, which I think you were shown briefly yesterday, one derives it from paragraphs 1 and 2, is that Mr. Cooper was an officer of the NCA, then soccer, who was dismissed after having been arrested by Sussex police for being drunk, disorderly and assaulting a police officer. And Sussex police, perhaps one might think unsurprisingly, passed the details of that arrest and that incident to the NCA, given the vetting clearance implications for Mr. Cooper. And Mr. Cooper was subsequently, following various processes, dismissed. And he said his complaint in his data protection claim was that the NCA had unlawfully processed the data passed by Sussex police in deciding and taking it into account when deciding to dismiss him. And just for your note, you see in paragraph 35, it's recorded that his claims issued in the county court against Soccer, complaining of a breach of duty on the part of Soccer. As against Soccer, he claimed compensation of £880,000 in relation to the loss of this employment and damage to his future prospects of employment. The appeal was also an appeal against employment tribunal proceedings, but those don't give rise to any specific data protection points, so I'm not going to focus on those. Important to see from paragraph 4 of Lord Justice Sales's judgment on page 257, the summary of why the court below held that the processing of data was lawful. It's really the final sentence. Judge Dyke held that there were a number of justifications for the processing of the data by Soccer, which were available to Soccer under the DPA, relating to its contractual rights as employer and its public functions as a law enforcement agency. So that's the emphasis of in paragraph 4 as to the core focus of the processing conditions in issue, not report will note the consent condition. It is also should also show you why you are here. In paragraph 6, Lord Justice Sales extracts relevant provisions from the employment contract. For these purposes, the relevant one is clause 24, headed data protection, in which it is said that signing up to the contract gives consent to the holding and processing of data relating to your employment by Soccer, and then further details about how Soccer will process personal data in clause 24.2. So that's, and Mr. Cooper obviously signed that employment contract. Paragraph 88 on page 275, Lord Justice Sells introduces the issue of compliance with the first data protection principle, and at 88 records that Judge Dyke was right to his conclusion that Judge Dyke was right to find that the processing was compliant with, in effect, all of the processing conditions in Schedule 2 of the DPA, all of which had been put in issue. And then, following some discussion of general principles about the meaning of necessary and so on, he goes on to address those conditions in turn and in the order they appear in Schedule 2, which means the first condition in issue is consent to processing between paragraphs 98 and 102, and you've seen some of these passages before. The particular focus in paragraphs 98 to 100 is that Lord Justice Sales agrees with the NCA and the judge below that the employment contract provided Mr. Cooper's consent to the processing in question and dismissed an interpretation of the language of the clause that would have excluded this particular processing context. And those are matters, those are advanced, as so far as one can tell from the judgment, solely as matters of interpretation of the contract and not as matters of Mr. Cooper's subjective belief as to what the processing would or might be. Paragraph 101, the submission is made. The specific submission that is made, one sees recorded, is that if there is any ambiguity in the contract, it is to be resolved in favour of the data subject. And the resolution of that submission comes at the end of paragraph 102. The final sentence, in any event, in the present case, I do not consider that there is any ambiguity or genuine uncertainty about the meaning of clause 24.2 when the full context is taken into account.
Well, you said ambiguity about the contract. In fact, the submission is if there is ambiguity about the consent, not the contract. That's the submission,
Yes, ambiguity about the consent allegedly given by the data subject, but
not the contract.
But it's the submission in support of the interpretation of the contract. That's what it says at the beginning of 101. So it's all linked. The submission is the overall submission, as you see from 98 to 100, is this is how the contract should be interpreted. That's rejected. Well, there's some ambiguity in precisely what that records. And because this is relied on as consent, you should resolve that ambiguity in favour of my client. And Lord Justice Earls says at the end of 102, well, there isn't any ambiguity. So that point doesn't arise. He does, of course, also say at the beginning of 102, a controller needs to know what its obligations are. So consent is objective depending on the outward manifestation of consent, including interpretation of the terms of the contract giving consent. That's the single sentence that is relied upon against me. Now, there is no dispute, and hopefully the court has got that this is my case from my submissions this morning, there's no dispute that consent requires an outward manifestation of consent by the data subject. But beyond that, we respectfully say that this single sentence has to be treated with some caution, notwithstanding the court from which it falls. First, it is not binding, as Miss Emerson suggested yesterday. The consent condition is one point in connection with a lawful basis of processing issue amongst many, and not one emphasised in the summary of the position of paragraph 4. But even within the discussion of consent itself, the ratio on this issue is that the contract unambiguously provided the consent to the relevant processing. Secondly, there is no suggestion that the current argument or any version of it was made to the Court of Appeal, or indeed the court below. Thirdly, it is with respect wrong on the application of the consent standard regardless of any subjective factors. It is, for example, very hard to see how this employment contract clause, which is not suggested was subject to any specific agreement, separate specific agreement, evidences the specific consent which has always been required, or how it could possibly stand in the light of the facts and circumstances in Orange Romania, with which there is some analogy. You recall in Orange Romania, a general signature to a contract was not accepted by the Court of Justice as sufficient evidence of consent to a data processing clause within that contract without proof of specific agreement to the clause.
I was just looking to see whether that point had been raised by Mr. Poppin. I can't see a sign that it was. There's no indication of the judgment.
I don't think there is any indication in the judgment, and that may be because there were other...
All sorts of possible misdemeanors.
Yes, it wasn't. But if one were running the same argument today, it is difficult to see how that conclusion could stand. This would not be a consent case. the outcome is undoubtedly right. There were available processing conditions, but it wasn't a consent case. It shouldn't have been a consent case. Fourthly, it also does not address the point, no doubt because it was not made, but it is entirely inconsistent with the principle that I've just shown you in the, for example, 2011 Working Party guidance, that the imbalance of power in an employment relationship will usually mean that consent cannot have been freely given, and that will be particularly so where it's the employment contract.
Consent cannot be presumed. Cannot be freely given.
Unlikely to have been freely given, I think is the language. So it would require careful investigation of whether it's appropriate to find consent in the context of an employment contract. And all of the indication from the guidance is that this sort of employment context is very unlikely to be a context of freely given consent, even if there can be other contexts within an employment relationship which would be okay. So for all those reasons, the point, it's the reasoning on consent in this judgment can't be taken as the determinative guide on the nuances of the issue that are before this court on an appeal from the judgment that you have, and in the light of the detailed arguments that you have heard both ways. That takes me, if I may, to the next head and the second outline submission I made at the very outset as to what the judge did. At the outset, my submission is that the judge got the substance, I emphasise the substance, of the law on consent in this case correct, and applied it correctly, at the least permissibly, to the specific facts and context that were before her, and about which she made findings. It is not our case that this court should positively endorse the particular three-strand approach with which the judge reanalysed the law of consent in this context as involving. We have some sympathy with the ICO submission that the three strands risk confusion, and I readily accept that it would make my job before your lordships and your ownership much easier if the judge had simply applied the language of the legislative provision without the analytical gloss on it. But that doesn't mean that the gloss conveys an error of law. The judge's analysis, and to pick up and answer my lady the President's question from yesterday, it is undoubtedly the judge's analysis, not analysis. The three-strand approach was not an analysis advanced to her by the parties. There are echoes of it in how the parties were advancing their cases, but she has developed that analysis. It is rooted in the materials we have considered and the purpose of privacy law and the role of consent with that, and her analysis is on any view thoughtful and principled. But nonetheless, we can see that it would be easier and more straightforward simply to focus on the language of the provisions of the consent standard as set out in the legislation. In substance, even when one reads the judgment fairly and carefully, nothing very novel is taking place. And the analysis the judge carries out is consistent with the test set out in the legislation, the language of which the judge repeatedly refers back to and returns to in the judgment, being whether consent was freely given, specific, informed, and unambiguous. And in particular, we say, when read carefully and fairly and holistically, the judge was well aware of all of the sorts of points that SBG now claims she has ignored and addresses them directly, what she ultimately concludes is very expressly and repeatedly a highly fact-specific decision to a highly specific factual context in terms of processing, data subject and point in time. The judge's reasoning commences on this issue, material reasoning, commences, as you saw yesterday, and I'm very conscious of the reminder the court gave yesterday that it has read the judgment and read the judgment on multiple, and no doubt has read it again since that warning was given. And I don't want to spend a lot of time making you reread passages you've read. So for the most part, I'm going to give you the references and you can glance at them as you go without requiring you to go through and read everything again. But the analysis of the judge starts on this point after a summary of the law on consent, standards for legally operative consent, between paragraphs 135 and 147, which is entirely uncontroversial and indeed not challenged, which you have said, which you have seen. And would you say, with respect, that it is not unimportant that a judge who it is said has fallen into serious legal error has done that exercise of setting out the law entirely uncontroversially? So she knows what the provisions are, she knows what the case law is and says, and she summarises that in a manner to which no objection is taken. And save possibly for the final, sentence of paragraph 147, about three distinct strands being perceptible in this complex idea, the summary of paragraph 147 of what the law is there to do is also unimpeachable. And what she was going on to do through the remainder of her judgment was try and explain what those concepts mean and how they should be applied in, as I've noted, on the authority of the unusual case of an individual data subject whose position was that he had not consented in the particular context of this controller and their processing by way of marketing of their gambling products. And she throughout comes back to either the totality of or elements of the language of the test for consent, and see, for example, and I'll show you various examples of those at different points in my submissions on all of the grounds, but for example, simply for your note, see paragraph 201 at the outset of her summary on page 118.
I think you were challenged yesterday by Miss Proust to show us the palpable presence in the authorities of the three-strand approach. Are you going to take up that challenge?
No, I'm not. I don't. To be fair, I don't think it was Miss Proust who laid down that challenge, but the challenge was laid down.
I was one who raised it to out myself.
Yes, I think it was, my lord.
But I'm not sure.
I'm not.
I was asking the question.
Yeah.
Whether there was anything to be found in the authorities that provided that palpable presence, and to hear whether you were going to identify for us.
Well, and now you've heard what I've identified, and really, I'm not sure it really assists for me to say whether that's palpable or not. We certainly say there is a presence in the authorities and the materials. I'm not sure whether I would have used the word palpable, but that's not really the point, and certainly not in and of itself an error of law. So you have my submissions on the legal consistency of the judge's approach with the language and the purpose and the case law and the guidance. The key point I want to emphasise from the judge's approach is that it is an intensely contextual evaluation of all of the circumstances drawn from the evidence the judge heard over 4 days of oral evidence and cross-examination at trial to reach an overall assessment against the statutory criteria for consent. And to repeat the point I made at the outset, I don't dispute that one of the factors the judge includes in her assessment of all of the circumstances is her findings as to RTM's state of mind. But it is not, as the submissions put it yesterday, the only factor, and nor is it, on a fair reading of the judgment, the determinative factor. And the judge herself repeatedly set out in the judgment that she needed to consider the full circumstances, of which RTM's mindset was just one part. And without necessarily inviting you to go through and read all of these references, paragraph 153, the authorities emphasise the fact sensitivity of the requirement for consent. Where consent is disputed, the relevant factual matrix is likely to include all three elements: an individual's subjective consent, quality of the autonomy in any decisions they made about consent, the evidential basis on which data controller relied in proceeding on the basis of consent.
What's the difference between the first two?
As I said at the outset, my lord, I'm not inviting you to specifically endorse the three-strand approach. The emphasis I take from paragraph 153 is that the relevant factual matrix includes a lot of things, and it includes the subjective mindset, but it also includes all of the material about the objective consenting process and the objective evidence that the controller has collated about the outward manifestation of consent and so on. And the processing and so on. Paragraph 154, final sentence, the full factual matrix in this case. Paragraph 161. Paragraph 161 on 108. There is the judge makes the general finding that she accepts the claimant's evidence and finds him a truthful and credible witness. She accepts his evidence, and the final sentence makes clear as to how that plays out. It is material context for considering the questions of consent, part of the factual matrix to be inhabited when evaluating his actions.
Can I just go back a step in relation to this part of it, where you say you're not shying away from the fact that in her judgment, the judge deals with RTM state of mind, but it's not the only factor you say, or a determinative factor. Just to be clear, in your closing submissions and during the course of the trial, there was evidence given by the claimant, and you referred to it in your closing submissions as well, about his condition.
Yeah.
I can put it broadly. What was the purpose of that evidence? And what was the purpose of your references to it in your closing submissions? Because I think in your closing submissions you acknowledged and you took up what in effect was the judge's offer, that the issue of a remedy, if it arose, could be dealt with separately.
Yes. So in part, this question will be answered more fully by Ms MacLeod in her submissions on ground one. To give you the short answer. The claimant's evidence and witness statement, I think, picking up on a query from my Lord Justice Warby yesterday, was produced in response in support of the totality of the case, so prior to any splits between liability and quantum. So obviously some aspects of his evidence as to the particular impact on him and the particular position he was in was going to be relevant to his claim for distress and potentially for in relation to causation for pecuniary loss. It was also relevant, or at least potentially relevant, to the aspect of the case about whether whether SPG was processing the claimant's health data. So in part, one had to establish, as the judge accepted, the claimant was in fact a problem gambler at the time, not something otherwise accepted by the defendant. I think the gravamen of the question my lady puts to me is, well, were you saying in your submissions on consent in closing my lady should be taking into account the subjective state of mind of RTM. And we weren't. We didn't say that. The short point that my then junior Miss McLeod will develop under ground one is SPG were. That is exactly the submission that SPG were making. We should take into account what the claimant did and what he thought he was doing. And specifically that he wanted this. That was how they put their case in cross-examination. Does that answer my lady's question, at least for now?
No, yes.
Paragraph 169 on page 110. And particularly the second half of paragraph 169, the judge talks about other aspects of the context. Context in which the boxes were ticked, part of the relevant factual matrix, and the power of evidence for it on which SPG relied. Crucial part of that immediate context was the nature and process of the box ticking exercises themselves and the quality of the information SPG provided or made available in the course of it. These are at least capable of furnishing the conditions for and providing more or less good evidence of an autonomous process of the necessary quality. So absolutely accepting and going on to make findings about, which I'll come back to under the next heading, the objective aspects of the consenting process, very much part of the factual matrix, she says. Paragraph 185, 114. Particularly towards the end of that paragraph, the authorities require that to be considered, to be assessed in the full relevant factual matrix. Doing so involves revisiting SPG's business model and what the authorities say about marketing to gamblers to consider where the law places the carriage of the risks involved. And then, and I'll come back to this in a second, the passage at 186 onwards is a particular analysis of the specific context of this processing by this controller of this sort of data and marketing. And in the paragraph 203, I made reference to this earlier, but I'll show you it again on page 119 at the end of that paragraph. On balance, and it may be a fine balance, my conclusion is that on the particular evidence of facts of this case, the quality of this claimant's consenting was rather lower than the standard required. And that is, we say, a clear reference, a clear indication the judge is giving that she is conducting a balance of all the factors that she has been considering and making findings about throughout the totality of her judgment, and making an on-balance finding that takes into account the claimant's subjective evidence, but obviously balancing against that, she is balancing that against all of the other factors. And so it can't be.
Where do we find that balance? I know she says she does it, but where do we find it? I mean, if you look, for instance, at paragraphs 182 and 183, she's looking at the system. She's already said that there are differences between the system at different periods, and that the system post the GDPR refresh was a perfectly good system.
Well, we don't accept that, but I'll come on to that in a separate section.
Then she says at 182 that she's already concluded that there's no subjective consent. 183, the SPG then saying, well, look at the risks, but she says no. The claimant's case is one of the irreducible minimum data subjects whose behaviour cannot in fact be read as either subjective consent of the requisite quality nor an autonomous decision. He was not engaging with it, he just felt compelled to gamble, and so on and so forth. And then at 185 she comes back to the question, but what, apart from the lack of subjective consent, which she with which she starts her analysis, what is it that's going to in some way override that lack of consent to provide consent for the purposes of the GDPR?
Well, she makes detailed
In
findings.
other words, it's a non-question in her analysis. Having decided that he didn't consent, nothing else seems to weigh against that.
Oh. The first and short point is that it would be a rather shorter judgment if that was the case. And that certainly isn't what the judge herself is saying. No. This isn't a reasons appeal. But in my submission, she is going through all aspects of all the circumstances. So she has made detailed findings about the claimant's subjective mindset. She makes detailed findings by reference to the different periods between paragraphs 172 to 170 to 178 in particular, which I'm going to come on to in more detail under a separate heading. But she makes findings, and largely critical findings, or significantly in part critical findings about the consenting processes. She makes findings in paragraphs 186 to 199 about, which I'm about to come on to, on the context of the processing and the nature of the quality of the safeguards that SBG were very strongly relying upon in their case, in terms of the risk models and so on, and how that all and I mean, true it is, I suppose, in some senses, that 203 is conclusory. This is how it cashes out. Down the balance and on a fine balance, I think it weighs out, it cashes out in this way, that it falls below the standard. But that has to be read against the totality of everything.
She goes on to say, I mean, 203, she goes on to say at 204, when she's, as it were, giving specifics of why not, why, to use your phrase, it cashes out in that way, because it proceeds directly from a damaged and defective condition of personal autonomy, with which the acts of consenting were inextricably and intimately bound up. So it all derives from his uncontrolled craving to gamble. So that looks to be the sort of root of it.
Well, I'm not sure.
Branch of it as well, if I.
Well, I'm not sure I would accept that, my lady. So I would accept the high point of my learned friend's submissions that it already turns on the subjective mindset is fairly the particular way, the particular emphasis that is given, particularly in paragraph 204. But I do say these paragraphs are expressly the summary, not the totality, and actually, as I say, I'm about to get on to, she is taking into account a variety of other considerations, and the conclusion as to where that balance comes out is shortly expressed in the summary, but that is nonetheless, she is saying in terms, I have done a balance, and this is what I say, this is how it comes out. You can't read paragraph 204 in isolation from all of the consideration of the objective processes and the merits and demerits of those, and the particular risk context of the processing in question. And that's what she deals with in some detail in paragraphs 186 to 199.
Can we discern what it is that the judge concluded about the individual components of consent test, just looking at it as a linguistic thing? Did she find that the consent was not sufficiently specific? Did she find, she may have found, that it wasn't unambiguous? Did she make a finding that it was not freely given? It's quite hard to know what she's driving at. I think she's using the test and this elusive concept of sufficiently autonomous decision making of a sufficient quality, rather than the language of the legislation.
So in part she is. But in some places, she clearly does make findings by reference to the specific language of the legislation. And I will be coming to those, particularly where they are adverse to SPG. And I accept. I think the reality is, and I think everyone, I think all parties accept the reality of the thrust of her judgment is that the focus of her judgment is really around freely given. It's not total. That's not the totality of it, because as I say, she's making findings about certain at different stages of the relevant period about whether the consent was properly informed and specific and unambiguous. But a number of the factors, particularly that are being taken into account about context, and for example, and on to this paragraph 199, she particularly takes into account she finds to be an imbalance of power. She doesn't say that's determinative, but she says it's part of the fact matrix, and that's a freely given part aspect of the matrix. And so I think that it's fair to say that the core of her overall summary is focused on freely given. It's not
the problem
always
I
the
have
language
with
she
analysing
uses.
this is that if one breaks it down into those component parts, accepting that there is no overlap between some of them, some overlap between all of them.
Yeah.
One way of doing this, which might be the simple way, would be to say, was it unambiguous, was it specific, was it informed, and answer those questions in turn, and then you would come to, well, it was all those things, or it wasn't. And then was it also freely given? And it's not clear to me at the moment whether she actually carried out that exercise, allowing for all the points you rightly made about having to read the judgment as a whole and benevolent. I'm left unclear as to whether everything went into the freely given box, or whether it sort of took into account that it was fairly clear, a bit specific or not. And that's this evaluative approach. That's a problem, I think, with the evaluative approach, because the test doesn't seem to be that it's got to be tick enough boxes enough.
Yeah. It's got to be
5 points on specific, plus 5 points on unambiguous.
I agree with that. That's right.
Makes 10. So I'm left unclear. You'll be able to help us, no doubt, after the adjournment on what the findings actually were.
Well, as I said at the outset of this section, I make no bones about the fact that it would make my life easier, and no doubt it would make the court's life easier if the judge below had done that exercise directed only by reference to the specific terms of the consent standard. That is not how she structures the judgment. No point arguing about that. It's clearly not how she structured the judgment. But it doesn't follow from that she isn't making those findings, and she does make specific findings about, particularly when she is assessing the quality of the objective consenting processes, distinctly by reference to the two particular periods in question. And as I said at the outset, I say she makes those findings with sufficient clarity by reference to the statutory language that you can be satisfied that even if she was completely wrong about any role for subjectivity, that survives. So I'll show you those. In terms of sort of the totality, as I say in paragraph 201, she is reminding herself of the specific linguistic requirements of the test. I accept that she does not then in the subsequent paragraph specifically call back to those languages in that language in the summary, but as I say, the substance of particularly her analysis across paragraphs 186 to 199 is around freely given. for example, that can be the only way. That's the only fair interpretation of paragraph 199, because that's a specific free concept in the legislation that links to freely given. And it is a
sorry, but if one looks at 202, having what she says in 201, talks about those measures, and then she comes sort of back to what she describes as the ineradicable risk. So that, as it were, that seems to be the core of the issue for her, which affects everything else.
well, but she also said.
Object is sort of
Sorry, my lady. She also says at the end of that paragraph that it's consenting behaviour which is too overborne, which is a fair paraphrase of freely given, not freely given, and ambiguous, i.e. not unambiguous. I'm conscious of the time. Having said I was going to keep going to things, it's probably best then to leave it till after the
Sorry, Anne.
No. Quite.
2 o'clock. Thank you very much.
All rise in favour?